Humphreys initially.
Thank you, and Gormahagut Lascan Corla. Given the complex historical basis of disabled persons' maintenance allowance and disability allowance, I welcome the opportunity to firstly set out the context of this matter for the House. Over the full period of some 70 years, there have been different allowances, time periods and legislative provisions governing these schemes, and it is important that these are clearly understood. Disabled persons' maintenance allowance for over 40 years constituted a weekly allowance paid by health boards to persons who are unable to work by reason of a disability. The scheme was first introduced under the Health Act 1953 and remained under the responsibility of the Minister for Health, the health boards and subsequently the HSE for over 40 years. Responsibility for the payment and administration of this allowance transferred to what is now the Department of Social Protection in 1996. At that point, the disabled person's maintenance allowance was discontinued and replaced by disability allowance. The introduction and nature of disability allowance was provided for in primary legislation at the time. And I should clarify that the legal concerns around the operation of this payment primarily relate to the period before the scheme transferred to the Department of Social Protection in 1996. Subsequent to the transfer of the scheme, there was a series of improvements that led to gradual expansions of entitlement to those persons in residential care settings. For example, in 1999, the Social Welfare Act made provision for the retention of entitlement to disability allowance where a person who had been living at home subsequently entered residential care. Additionally, the Disability Allowance personal expense rate was provided for in the Social Welfare and Pensions Act 2005, and this was payable at an amount of €35 per week. This payment replaced and standardised the spending allowances that had been paid by the health boards to people in residential care who were excluded from disability allowance due to being in residential care. This move meant that all persons in residential care could apply for the payment. It represented a decisive step towards the provision, through legislation in 2007, of full-rate disability allowance for all people in residential care settings who met the other qualifying criteria for the scheme. This series of gradual improvements in entitlement was advanced across several budgets that had, of necessity, a regard for a range of competing priorities at those times. Given the time span during which the restrictions on payment to persons in residential care have been progressively relaxed, these issues are historical. They relate to arrangements which have been superseded for many years. Furthermore, the legislative basis for the allowances and their payment changed on a number of occasions during this time span, and this adds to the complexities of the matter. As a result of these complexities, and in response to public concerns, the Government asked the Attorney-General to review the files in the Attorney-General's office. These are in regards to A, charges levied for the provision of nursing home care, and B, the non-payment of the disabled person's maintenance allowance to persons in residential care, and to provide an account of the litigation management strategy adopted by the State insofar as it was based upon the legal advices provided by previous Attorneys General and the Office of the Attorney-General. My colleague, the Minister for Health, has spoken to the matters relating to the nursing homes aspect. The Attorney-General's report was received earlier this week. The Government has noted the report and it has been laid before the Houses of the Oireachtas and published. The report analyses the nature of the State's approach to civil litigation and provides an explanation of the litigation process. Around the time of the more significant expansions of entitlement I mentioned earlier, in the period 2006 to 2008, a legal challenge was made to the validity of regulations made under the 1970 Health Act in respect of the period 1983 to 1996. The Attorney-General did not consider it appropriate to name individual plaintiffs in circumstances where their litigation was compromised in a manner to their satisfaction on a confidential basis, and Likewise, I do not propose to do so. I understand that this challenge sought to establish a right to the payment of disabled persons' maintenance allowance to people in residential care settings in a manner that was neither in line with the long-standing and well-understood government policy of the time, nor with the legislative intent of the Oireachtas as expressed in the 1996 Social Welfare Act. These details are set out in the report of the Attorney-General. However, rather than contesting that claim, the State decided to compromise the case, for reasons also set out in the Attorney-General's report. In the view of the Attorney-General, this was a legitimate legal approach which did not, in fact, as some have portrayed, attempted to force the person concerned through the courts, but rather led to the State reaching an agreed settlement with them. The settlement was not secret. It was reported in the press at the time, was ruled before the High Court and was subsequently the subject of a parliamentary question. The question that has been raised in recent public discourse is whether the settlement of this case automatically means that all people who might potentially have made a similar claim were denied an entitlement and should now receive a similar settlement. The view of the Attorney-General is that, even if the case concerned had been contested in court, and even if the regulations concerned were determined to be invalid, it does not follow that there would have been an obligation to compensate people who may have benefited from a payment in the absence of the regulations that specifically excluded them. The Attorney's report sets out that the State had no positive obligation to provide redress in the cases concerned. There are many documents to consider dating back over a 50-year period, and that is why it is important that adequate time is given to consider the issues at hand. And I, together with my colleague, Minister for Health, have been asked to review these matters and return to government within 3 months. In conclusion, I think it is important, however, that we do not provide mixed messages on this, and that people with disabilities can be assured of this government's ongoing support. In Budget 2023, a number of important supports were brought forward for people with disabilities, including a cost of living double payment, a €500 cost of living disability support grant, a Christmas bonus double payment paid in December, a €12 increase in weekly payments with proportionate increases for qualified adults. Domiciliary care allowance was increased by €20.50 to €330 per month. Domiciliary care allowance is also being made available in respect of children with severe illness or disability who remain in hospital for up to 6 months after birth. The earnings disregard for both the disability allowance and blind pension was increased by €25 per week, from €140 to €165. And these measures build on a range of supports provided over successive budgets, such as improvement to the wage subsidy scheme to facilitate employment of persons with disabilities, publication of a cost of disability report, introduction of legislation, Catherine's Law, to facilitate further education by people with disabilities, extension of invalidity pension to self-employed contributors. So I want to assure the House that the Government remains committed and ambitious in its support for people with disabilities. And I look forward to hearing the contributions later. Last can call you.
So in addition